Good afternoon, and thanks for joining Washington, D.C.-based Jennifer Schaus & Associates in our Get FAR Cited in 2020 complimentary webinar series. As you know, the FAR, or Federal Acquisition Regulations, is the rulebook that the federal government must follow when making purchases. Our webinar series pulls from contracting experts to explain each part of the FAR. It is complimentary and recorded. We'll post all of the recordings on our website and YouTube channel, where we have over 400 government contracting webinars available for download. A special thanks to our webinar partner in this series, the National Veteran Small Business Coalition Education Foundation. Please visit their website to learn more about the organization. We would also like to thank our friends at Open the FAR for their sponsorship. If your organization is interested in sponsoring the series or one part, please contact hello@jenniferschaus.com. And now a little bit about us. We work with primarily large businesses to help them navigate the federal marketplace. We work with both product and service companies as well as software firms. Our clients span the globe and include publicly traded organizations in a variety of sectors. We provide market analysis reports, contract administration, contract vehicle assistance, and more. All of our services can also be built into a training course for your team. Learn more about us on our website. And now we would like to let you know about some ways to reach government and government contractors through us. We offer advertising and sponsorship opportunities through our weekly newsletter and also in our webinar series. For pricing or to place an order, please email us at hello@jenniferschaus.com. As noted, we also have over 400 webinars in our archives. As we continue to educate federal contractors, I would like to bring you to your attention to our webinar schedule for 2021. The full schedule and speakers are all confirmed. First up is a monthly series called the GovCon Live Q&A Cafe. This is a live webinar series held each month. These will take place on the second Friday of each month in 2021 at 12 p.m. Eastern. We've assembled a group of 4 panelists who are subject matter experts on a specific federal contracting topic. The panelists will make a short presentation about the topics listed here on your screen and then take your live questions about that topic. So for example, January will kick off with our panelists covering CMMC on Friday, January 8th. Our panelists include attorneys, consultants, and other industry professionals. You can sign up on our website under the Q&A Cafe tab. Sponsorships are available. Please email hello@jenniferschaus.com for a media kit and pricing details. In our second webinar series in 2021, we will be covering each part of the DFARS, or Defense Federal Acquisition Regulations. Similar to our current FAR series, this will be a weekly series dedicated to defense contracting, its rules and regulations. This series is complimentary and will be held on Wednesdays at 12 p.m. Eastern. We will run through the parts sequentially, which means that we start the year with DFARS Part 201 and finish with Part 252 at the end of the year. You can sign up on our website at the DFAR tab. And again, sponsorships are available. Please email hello@jenniferschaus.com for a media kit and pricing details. Now let's move on to learn more about today's speaker, Noelle Slivka. You can find her contact information here. And today we are covering FAR Part 46 with Noelle. Thank you so much for joining us today, and the floor is now yours.
Thank you. Thank you very much, and welcome everyone. As Colton said, my name is Noelle Slivka, and I'm a government contracts attorney located in Connecticut. For about 20 years now, I've worked for and with manufacturers delivering products and services to the federal government. I served as in-house counsel for a couple of divisions of a major aerospace manufacturer, and more recently as outside counsel advising companies in the government supply chain, mostly contractors supporting the Department of Defense. So today, I will cover Federal Acquisition Regulation Part 46, Quality Assurance. Next slide. FAR Part 46 sets the general rules for how the federal government ensures that it's getting what it's paying for, both in terms of quality and quantity. FAR Part 46 covers contract quality requirements in Subpart 46.2, quality assurance or oversight of quality in Subpart 46.4, which includes government inspection of goods, services, and construction, and acceptance of products, services, and construction in Subpart 46.5. So for ease of reference in this presentation and to provide a construct for learning about quality assurance under the FAR, I will often refer simply to products, or interchangeably I might use the term supplies or goods or items, in describing the requirements for quality assurance under the FAR. Understand, however, that quality assurance also applies to services and construction. And in those cases, there may be specific terms in the contract that are unique to quality in the service and construction sectors. The general principles will be common to products, services, and construction, and really everything the government purchases. But always be sure to read your contract to know what it requires. And in fact, I would say, generally speaking, when you want to understand what your contract says, there's no there's no substitute for simply reading the contract. But today we'll talk about some general principles. And because the government does not always get perfect quality, FAR Part 46 also covers two key aspects of a contractor's responsibilities after government acceptance. And those two areas are warranties, covered in subpart 46.7, and contractor liability for loss or damage to property of the government in subpart 46.8. On this slide, you'll see that I don't refer to government property in describing the topic covered in subpart 46.8, and this is intentional in order to avoid confusion. FAR subpart 46.8 refers to property of the government in the largest sense of the phrase, all equipment, tools, buildings, etc., that are owned by the federal government. If you're seeking guidance on contractor responsibility for specialized tooling, special test equipment, items that may be sent out for maintenance or repair, or other government property that's in the possession of a contractor as part of contract performance, look to FAR Part 45 for those requirements. FAR Part 46, specifically subpart 46.8, covers the contractor's liability for government property loss or damage due to defective work after acceptance of the work, like if the contractor sells a defective aircraft part that causes a loss of the entire aircraft. If that were a situation that you were looking at, FAR subpart 46.8 and the corresponding clauses in 52.246 would be the first place to look to determine the responsibility of the part manufacturer for the loss of the aircraft, as opposed to FAR Part 45. FAR Part 46 also contains definitions of certain terms used in this part of the FAR. There are clause prescriptions, meaning instructions on when to include the clauses found in FAR 52.246, and general guidance on material inspection and receiving reports. That is the documentation that demonstrates inspection and acceptance of products, services, and construction. Going along with FAR Part 46 are the clauses found in 52.246. The clauses are where the rubber meets the road in terms of the contractor's responsibility under the contract. Clauses are set forth in FAR Part 52 and incorporated by reference in the contract, and those are in fact the contract requirements. And the rest of the FAR Part 46 in particular, is in essence a set of instructions to government contracting officers. Now that doesn't mean that FAR Part 46 or the other parts of the FAR besides FAR Part 52 are not interesting and important for contractors to read and understand. FAR Part 52 contains the clauses, but the instructions in the other parts of the FAR, including FAR Part 46, are as important for the contractor to read and understand as they are to government personnel, because FAR Part 46 explains the government's obligations and authorities in the areas of quality assurance, as well as the principles behind the FAR clauses. Also, not all of the 25 quality assurance related clauses will appear in any one contract. And in fact, many are discretionary, as I will explain. Next slide. So let's start by going over contract quality requirements. FAR Part 46 does not actually include any particular specifications or statement of work requirements. Those would be found in the contract itself. So if you want to understand what the specifications or statement of work requirements are, including specific inspection and testing requirements, you want to look to the contract for those requirements. And those contracts and those requirements are going to be specific to the products or services being sold under that contract. FAR Part 46 covers quality systems. That is the process by which a contractor performs a contract in a manner that will produce the required result. And if the required result has to be produced multiple times, in a manner that the required result will be produced consistently with perfect quality every time. So it's a quality system. FAR Part 46 lays out 4 general categories or methods of setting quality requirements in government contracts. Those 4 categories depend on the type of product or service being purchased, as well as the dollar value of the contract. So let's go over those. The first category is commercial items. That is, generally speaking, items or services of a type sold for non-governmental purposes to non-governmental customers. There are other parts of the definition of commercial items that are found in other sections of the FAR, but just generally speaking, we're talking about things that someone other than the government buys. But when the government buys those commercial items, the government will be treated as it would any other customer. And in the case of quality assurance, the government will rely on the contractor's existing quality assurance system. And that's really regardless of dollar value of the contract. So much like if you were to buy a new car, you're relying on the car manufacturer's quality system to ensure that you're getting the product that you expect and that you're getting the product that meets safety standards. And the government operates the same way. If they're buying a commercial item, they're relying on the contractor's existing quality assurance system. For non-commercial items and any contracts at or below the simplified acquisition threshold, which is currently set at $250,000 with a higher threshold for certain types of products. But below the simplified acquisition threshold, the government will rely on the contractor to perform inspections. For contracts above the simplified acquisition threshold, the government has the right to inspect the products to verify compliance with the contract's requirements. And those can be very general inspection requirements. Finally, though, for complex items, critical items, or items that are high risk if there is non-conformance, either high risk in terms of the probability of occurrence or the consequence if the non-conformance occurs. For high-risk, complex, or critical items, the government will include higher-level quality requirements in the contract. Higher-level quality requirements are often incorporation of system standards that are set by third-party standard or accreditation bodies such as ISO 9001. So generally speaking, the higher the value, complexity, and risk of the item or service, the greater the government's involvement in defining the quality system and inspecting the work. There's also quite a bit of discretion on the part of the government in setting quality requirements in the contract, and FAR Part 46 goes through some of the considerations that the government should take under advisement in setting quality requirements. Understand, though, that in government contracts, the flip side of discretion on the part of the government is the contractor's opportunity to negotiate. So if the government can and may and has authority and has discretion, often that's an opportunity for the government, for the contractor to negotiate. So before accepting a contract for all of the contractors out there, I would advise that the contractors pay close attention to the quality system requirements in the contract and verify the ability to comply with those requirements. And if you can't, to negotiate or discuss requirements that the contractor can meet and that the government finds acceptable. Next slide. So there are several different inspection clauses prescribed by FAR Part 46, and that's the next topic we're going to discuss, which is inspection. Those clauses, which clause the government should include, depends on the contract value as well as the contract type and the type of product or service being purchased. So listed here, there are a number of separate clauses. There are separate clauses for supplies purchased on a fixed price basis, and a different clause if those supplies are purchased on a cost reimbursement basis. And the same is true for services. One clause for fixed price, one clause for cost reimbursement. For time and material contracts or labor hour contracts under which services are provided at an hourly rate and any material, usually incidental material, is billed at cost, there's a separate inspection clause for those types of contracts. Research and development has its own clauses, depending again on whether the contract is fixed price or cost reimbursement. Construction has its own inspection clause, as does demolition, which is actually a separate clause from construction. And finally, transportation. So depending on what is being sold, the contract type, and the contract value, there are different clauses for inspection that are prescribed. Next slide. So although there are different versions of the inspection clause depending on what and how the government is buying, there are some key aspects that all of the inspection clauses have in common. Number one, the clause will cover the contractor's responsibilities with respect to the contractor's quality system. Two, the clause will cover the government's rights to oversee the system and inspection rights with respect to the work being done. And three, the clause will cover the government's rights and the contractor's obligations if the work is non-conforming, does not comply with the contract. Underlying the inspection clauses is the fundamental principle that the government has the right to 100% compliance with contract requirements. The government has negotiated and has committed to buying a certain product with certain quality requirements, testing, inspection requirements, etc. And the government has the right to expect full compliance with those requirements. In other words, the government has the right to get exactly what it is paying for. The old expression, close enough for government work, should never be the attitude of a government contractor. And anyone who's been through the inspection and acceptance process with the government for a critical item will understand that there is no such thing as close enough for government work. Under the inspection clauses, the contractor's obligation is to maintain an inspection system that is, depending on the wording of the clause, either adequate or acceptable to the government. It's actually very general, the standard. And adequacy is judged by the government, not by the contractor. The contractor must then present for acceptance only work that has been performed according to its quality system and retain records of inspection and testing for the period required by the contract or longer if required by the quality system. So it would be the contract record retention period or the quality system record retention period, whichever is longer. The government has the right to inspect and test the work, review records, and actually to review or audit the quality system overall. So even if the contractor is certified under a third-party standard system, the government still has the right to audit the contractor's quality system and may find deficiencies. Included in these rights is the right to have access to the contractor's facilities or work site and that of subcontractors. So the government actually has to have the right to have access to the contractor's facilities, that of subcontractors, in order to perform quality assurance duties. If the government performs on-site inspections or testing, the contractor must provide reasonable facilities and assistance for safe and convenient performance of the government's oversight responsibilities. So, for many contractors that perform a significant amount of work for the government employees may have offices at the contractor's site. The contractor's facility may be the government employee's place of work day in and day out. And the facility's assistance must be provided to the government at no increase in contract price. Next slide. So quality assurance. Quality assurance is the government's oversight or surveillance of the work. Note that even when the government is highly involved in oversight and inspection of the contractor's work, that does not excuse the contractor from its obligation to perform inspections and tests according to contract and quality system requirements. The government's inspection rights are over and above the contractor's obligations. Let me pause here for a moment and discuss the concept of delegation on the government's part and how the government actually administers government contracts in many circumstances. The procuring contracting officer, or PCO, is the government employee who's authorized to bind the government contractually by awarding the contract, and that is the person who overall has responsibility for the contract. Often, however, the PCO, the procuring contracting officer, will delegate authority to oversee contract performance and accept completed work to an administrative contracting officer, or ACO. That administrative contracting officer, or ACO, may have assistance from other government employees who operate as a team to oversee contract performance. An example is for the military services. The Defense Contract Management Agency, or DCAA, performs contract administration responsibilities for most DoD contracts. And although there may be a team of government employees involved in contractor oversight, ultimately only the ACO, the Administrative Contracting Officer, will have authority to bind the government contractually in its administration responsibilities. And the ACO's authorities may be further limited by the scope of the delegation from the PCO, or procuring contracting officer. And in that case, if the ACO is not authorized to do something, then that action would have to go to the PCO, and the PCO would then have the discretion and responsibility for making decisions and binding the government in contract. In addition to delegation of contract administration, the government will prepare a quality surveillance plan in conjunction with the contract statement of work. The surveillance plan will include a description of the work requiring oversight and the method of oversight. In addition, the contract will state the location of government inspection, for example, at source, or meaning at the contractor's or the subcontractor's manufacturing facility. And the contract will also state any inspection requirements that may be required at intermediate stages of manufacture. So, for example, if a critical part of an aircraft engine is not able to be inspected once the engine is fully assembled, the government may include in the contract intermediate inspection requirements, where the government will come in and do inspection at a point in the process before final delivery of the item. The government's inspection will be recorded on the material inspection and receiving report, or commercial shipping document if that's applicable. FAR Part 46 defers to individual government agencies to determine and provide instructions on completing inspection and acceptance documents. So each agency may have a different form and different methods of recording both inspection and acceptance. For example, the form that is used by the Department of Defense is called DD 250. Next slide. As I mentioned before, the government has the right to expect full compliance with contract specifications and with a statement of work, including all testing and inspection requirements. So let's talk a bit about nonconformances. The general rule is that nonconforming work should be rejected. However, FAR Part 46 does allow the government to give the contractor an opportunity to correct deficiencies if that can be done within the required delivery schedule. And FAR Part 46 gives the government the authority to accept work with minor nonconformances. Understand, however, that the government may allow for corrections or even accept minor nonconformances, but there's no requirement that the government do so. That is within their discretion. Minor nonconformances, as opposed to major ones, minor nonconformances are deficiencies that do not affect safety or performance of the product for its intended use. Government technical experts will weigh in on whether a nonconformance is minor or major, and if minor, whether acceptance is advisable. Keep in mind, however, that the government technical expert does not have the authority to accept products or services, nor does he or she have the authority to modify the contract or otherwise bind the government contractually. Only a contracting officer for the government has that authority. Even if the government determines that work with minor nonconformances is acceptable, the government should obtain a price adjustment or other consideration to reflect a loss in value or the administrative burden to the government of accepting minor nonconformances. When I refer here to the term consideration, I mean an agreement to do or not to do something by one party to a contract in exchange for an agreement by the other party to do or not do something. Typically, consideration is money in exchange for work, or in the case of nonconformances, a reduction in price in exchange for acceptance of work with minor nonconformances. However, consideration does not have to involve money, and it could include the contractor taking corrective actions in exchange for the acceptance of minor nonconformances by the government. And this approach can have the added benefit of the contractor making improvements to its quality system to prevent recurrence of the same types of minor nonconformances. Next slide. Acceptance. Acceptance is the contracting officer's acknowledgement that the work conforms to contract requirements. Acceptance is documented on the material inspection and receiving report that's prescribed by the government agency making the purchase. There is a FAR clause, 52246-15, that is a contractor certificate of conformance. And I want to mention this for a moment because I think this can cause some confusion. This FAR clause, 52246-15, is limited in its prescription or instructions on when it should be used. It's really only supposed to be used as a substitute for government source inspection. And given the range of inspection rates that the government may impose, depending on the type of contract and product or service being purchased, the contractor's certificate of conformance is often the exception, not the rule. Some contractors, however, may routinely include a certificate of conformance even when not required by the contract or subcontract, and even when the government performs its own inspection. For the contractors listening to this presentation, I just want to encourage you to be mindful of the consequences of signing unnecessary certificates under government contracts. Because if the information or that certificate of conformance, if the information is being certified, turns out to be incorrect, the certification, even if not required, could be viewed as false information provided to the government. If a certificate of conformance is not required, don't sign one. However, there may be circumstances in which it is required, and that should be known to the contractor going into the contract, and then be careful about the accuracy of those certifications when they're being signed. So acceptance. Acceptance is a significant milestone in a government contract, not only because it allows for payment of the work, but acceptance transfers title and risk of loss of product to the government, even if the products have not been physically transferred or shipped to the government yet. Key also about acceptance is that under many of the inspection clauses, acceptance limits the contractor's responsibility for defects discovered after acceptance, and even loss or damage due to the defects. So acceptance has a very important impact on both the government and the contractor. For example, under the fixed price supply inspection clause found at FAR 52246-2, acceptance is final, meaning the government accepts responsibility for the work, except for latent defects, fraud, gross mistakes amounting to fraud, or as otherwise provided in the contract, such as a warranty. Let me discuss the concept of latent defects for just a moment. Latent defects are defects that are in existence at the time of acceptance and not discoverable by reasonable inspection. They had to have existed at the time of acceptance, they were not discovered, and they were not discoverable by reasonable inspection. If a product has a patent, I mean patent as opposed to latent, or discoverable defect that is missed during inspection, the contractor is not responsible for that defect unless another exception to the finality of acceptance applies. So fraud, gross mistakes amounting to fraud, or as otherwise provided in the contract, such as a warranty. But if none of those other circumstances exist, and the product has a patent or discoverable defect that is missed during inspection, the contractor is not responsible for that defect. Now, that does not mean that a contractor may knowingly present a defective product for acceptance and then escape responsibility if the government's inspection does not catch the defect. Knowingly presenting defective work, including work that has not gone through a required contractor inspection and testing, is fraud, which negates the finality of acceptance and comes with stiff penalties under the law. If the contractor knows of defects, but believes that the defects are minor nonconformances, the contractor may present the work with full disclosure of the nonconformances, and the government then has discretion as to whether to accept the work or not. But always disclose, as a contractor, any known nonconformances before presenting an item or work for acceptance to the government. Next slide. Warranties. Warranties are not mandated in the government contract, and this part of the FAR is one of the areas where the government probably has the most discretion. The principle here is that the government generally self-insures against defects discovered after acceptance and does not purchase warranties. The government generally acts a lot like you would when you're buying a television set and the folks try to sell you on the extended warranty. Many people say, you know what, I'll take my chances that there might be a problem with this product in the future, and I won't buy the extended warranty because I consider the risk and the possible cost of having to repair that item to be less than the cost of the warranty. And the government operates essentially the same way. In certain circumstances, however, and with consideration of the cost of purchasing a warranty, the government may include warranty requirements in a contract. And also, FAR Part 46 advises the government that if a product or service, including a commercial item, customarily comes with a standard warranty, and that warranty is included in the price of the product, then the government should get that standard warranty as well, and that standard warranty should be included in the contract. FAR 52.246 contains several warranty clauses for different types of products and services, but FAR Part 46 allows for tailoring of warranty terms. It is one of the rare areas of FAR where the regulatory clause, the clause that is set out in regulation, may actually be negotiated and changed. The scope of the warranty may be changed, the remedies may be changed, and there's actually a lot of opportunity for negotiation in warranty clauses. Next slide. Contractor liability after acceptance. So we've gone through the process of doing the work, performing the work according to the quality system. The government has done the inspection that is permitted under the contract, and the government has accepted the work. The contractor's responsibility or liability for defective work is at that point limited after government acceptance. That is, again, because the government generally self-insures against the risk of government property damage or loss due to defective supplies or services, rather than paying for the contractor to obtain insurance to cover that risk. There are really several clauses that operate together to limit the contractor's liability after acceptance of work. The first is the inspection clause. For example, the language that we covered earlier in this presentation regarding the finality of acceptance with some exceptions. The second type of clause that limits the contractor's liability would be a warranty clause, if any, because that warranty clause would have a scope and limitations and remedies and limitations on those remedies. And if there is no warranty clause, then there's no warranty. Finally, the contract should have a limitation of liability clause. The basic limitation of liability clause does not limit the contractor's liability for the defective item itself. So if that item were to break and there's responsibility under the contract for it, then the contractor would at least be responsible up to the dollar value of the defective item. But if the item is considered high value, and that's generally valued at greater than $100,000, the contractor is not liable for the defective item either, under the limitation of liability clause for high value items found at FAR 52.246-24. So if a contractor is selling an aircraft engine going into an aircraft, and they have the limitation of liability clause for high value items, FAR 52.246-24, and there's no exception that applies, and the product was accepted, and there's a defect that causes not only the loss of the aircraft engine, but the loss of the aircraft, the contractor's liability for that, the cost of that damage or loss is limited, and in fact is zero. There is, however, an exception to the limitation of liability in government contracts, and that is if the damage or loss is due to willful misconduct or lack of good faith by contractor managerial personnel. That's a fairly high bar to overcome, meaning you'd have to have willful, intentional misconduct or lack of good faith by not just anyone in the company, but the contractor's managerial personnel, which is defined in the FAR. Note also that the limitation of liability we're talking about here only applies to damage or loss to government property. These clauses don't limit a contractor's liability for personal injury due to defective work or third-party claims. There is another body of law that defines the boundaries of what is known as the government contractor defense. And the contours of that defense have been established based on judicial decision, and those are separate from the regulations that are the subject of this presentation. But I wanted to mention the government contractor defense because it is something that could become an issue that you might see when there is loss, damage, destruction, or personal injury based on defective work under a government contract, but it is separate and apart from the clauses and the rules we're discussing here in this presentation. Next slide. So there is one more recent clause that is worth mentioning, and so I have a separate slide on that one, and that is the requirement to report non-conforming items under FAR 52-246-26. You'll see that this clause came into existence in December of 2019, so it is fairly new, less than a year. In response to concerns about counterfeit materials and other major nonconformances in critical items, the government created a clause that requires monitoring and screening of the GIDEP system, or the Government Industry Data Exchange Program system. It's a database to identify materials or components of concern. And to report, this clause requires reporting of both counterfeit or suspect counterfeit parts, as well as major or critical nonconformances, both to the government and to the GIDEP system, within 60 days of discovery of a reason to suspect that the item is either counterfeit or a major nonconformance. So it's a 60-day clock. It starts from the point of discovery, but not necessarily confirmation. It's 60 days of the date of the reason to suspect that there's a problem. So this clause is in FAR Part 46 because this obligation would survive the acceptance of product or services by the government. So this really relates more to parts and products. But if those parts and products have been sold to the government, but are then suspected of counterfeit or major nonconformances, those would have to be reported even if they've already been accepted by the government. And of course, as the contractor is going through its manufacturing, the screening of GIDEP should be occurring regularly to ensure that parts and materials that are of concern and have been notified in the GIDEP system or have been alerted in the GIDEP system are not being used in that manufacturer's product. Next slide. So FAR Part 46, let's summarize. To summarize the principles of FAR Part 46, quality assurance is really the process for confirming that the government is getting what the contract requires. Unlike many other parts of the FAR, the government has a lot of discretion on the clauses in this area. That is, which ones will be included, and even with respect to warranty, the language of the clause itself. That is somewhat unusual under the FAR. Also key to FAR Part 46 is that it explains why government quality assurance is a significant government activity. There are a lot of personnel, a lot of time and energy put into government oversight of contractors' work. And that's due to the importance of obtaining quality products and services. And in addition to that, it's due to the limitations on the government's rights once work is accepted. And finally, there are growing concerns about counterfeit material and major nonconformances in products that the government purchases. So for those three reasons, mainly, there is a lot of energy, personnel, and time put into government oversight of contractors' work. Finally, FAR Part 46 establishes a net of clauses that operate together to allocate the risk of defective work between the government and the contractor after that work has been accepted. And that's really important to understand. And it's really about an allocation of risk that is based on cost and benefit. As I mentioned in this presentation, the government has made decisions in many cases that are about economics and about costs and about the cost of self-insuring against risk. And it's really not about, fairness and should and all of that. So when there is defective work that is discovered after acceptance, FAR Part 46 is the area to look at those net of clauses that together operate to allocate the risk of that defective work between the government and the contractor. Next slide. So that concludes this presentation. Questions may be directed to my contact information in these slides or to Jennifer Schaus & Associates. Thank you for joining us.
Thanks for a great presentation, Noel. And to our audience members, we thank you again for participating with us. If you have questions about this part, please contact our speaker with the contact information seen on your screen. And if you have any questions about federal contracting or need assistance with any of our services, please contact us directly. Thank you again for joining us. This concludes today's webinar.